Now, as I said, we're almost done with day 2 of the Bitkom Privacy Conference. We have one last slot left. It says closing keynote. You won't get a closing keynote, but you will get a closing discussion. I'm very happy to welcome Dr. Axel Spies from Washington, D.C. I'm very happy that you're here today with us. And we thought that at the end of the day, it would be very nice to have a short interview kind of thing and have a look at the privacy privacy state in the US. I think that's very nice. And we thought of a few questions. And Mr. Spies, I'm very happy that you're here. And maybe we start with a look at the status of privacy legislation in the US. How would you describe the current state of privacy legislation in the US, especially compared to the GDPR in Europe?
Yeah, hello. I hope everyone can hear me.
We can hear you and see you.
Fantastic. Greetings from the Watergate complex here, which has its own issue with break-ins and privacy in the past. It's a lot of history here. So I'm more than happy to answer your questions. I've been here for 25 years on the ground. Doing privacy work, and also I'm very active in Germany with the ZD and the MMR, the two journals. So to start with your questions right now, the privacy legislation in the United States, it's a patchwork, and it will be a patchwork. A patchwork means that we have a lot of different privacy laws in the single states, but not that much on the federal level, which is really a headache for many companies. For instance, if there's a data breach, you have 50 states and they have their own laws what to do in these cases. So that's really a challenge. For the Europeans, they always look at California. That is the only state with an independent regulator, the CPPA. But that's not the only state. There are several other models there. I bring to your attention, Texas has its own privacy law that's quite advanced. Another model is Virginia and Colorado, Utah. And there are states that don't have anything. So you have to really look around and see what's going on here. There are efforts there to get a privacy law done on the federal level, but they are more or less stalled. There are certain rules there that apply to certain industry, especially healthcare and the financial industry, Gramm-Leach-Bliley Act and so forth. So that is something that is really out there and causes a lot of compliance work, but no federal privacy law.
And do you see any realistic prospects for a federal law, or will the patchwork of state level, as you said, will remain?
The problem there is basically the states that have privacy laws say, oh, I don't want to give up any standards. Mm-hmm. That's especially true for California. The issue is called preemption. That means we have that in Germany too. Bundesrecht bricht Landesrecht. So we have that in the United States, preemption. And they have really struggled hard to keep their level of privacy and the regulator and so forth. So if there would be a law on the federal level, they would probably have to give up some of their standards, and they don't want that. So it's a political football. It's up and down. I don't see it coming.
Okay. And if we now look at the companies, what do you think, what practical consequences does this state have for or the lack of uniformity have for international companies, and especially in particular?
Well, we're dealing with that a lot. And the issue is they mostly look at California and then they think they're done. That's not the case. And if you look at privacy policies in the United States, they're extremely long. And they have attachments that say, well, for residents in California, we have these rules, for Colorado those, and Maryland other rules. So they are getting really, really long and complicated. There are also thresholds. The laws are consumer protection laws. They apply mostly to consumers with some exemptions. And therefore, there's a lot of compliance work necessary to comply with all the different states.
If we now maybe take a look at, it's not getting easier, but at AI, the AI action plan aims to secure US leadership in AI. In your view, which political and legal motives are there at the forefront?
The AI action plan that came out a few weeks ago is a political document. And it's nothing really new. They have started the process in January with a consultation here, the Trump administration. The goal is very different from the AI Act. The goal is to protect American industry and national security. China is the big opponent, not the Europeans. So the hope is that they sell their AI products in a bundle. That means chips, AI applications, and maybe hosting here, a lot of data centers here. I think that's a little bit far-fetched and ambitious because the chip makers, they're not really cooperating with the cloud service providers and so forth. So the AI action plan is more directed at the government to jump into action. President Biden had done the same, so it builds on that. Actually, but in the end, the issue is not that much to regulate AI, but to enhance it and to create new jobs, new data centers, and new resources to promote the American way of AI, if I can say that.
Yeah, you kind of already answered my next question, but I'll tell you anyway. The plan also mentions the full stack AI exports, as you said, bundling hardware, software, data standards. And what, in your view, what do you think, how realistic is this model at present?
Not very realistic. I mean, the other day we had a big dinner here at the White House with President Trump presiding with the CEOs. He wants to go through the CEOs and he forces them to invest in the United States. He wants to promote AI services overseas, of course, but in a way that he thinks it should be done. And they don't really care about the AI Act in Europe that much.
And what do you think could that mean for Europe?
Well, for Europe, it means, first of all, there could be a tug of war as to which model will reign the future. They think here that the AI Act is totally going overboard, regulates an industry that should not be regulated. And there are some features in it where they may come to an agreement, but other than this, they are not happy with it, in particular with the rules that European copyright should be accepted by American companies for training their AI systems. They don't think that is necessary. That may not be necessary under the rules here in the United States with fair use, but that's a different, certainly a camp where the two jurisdictions clash, and we'll see how that turns out.
Last week we had the General Court's La Tombe decision. Maybe I think every one of our participants heard about it, but maybe you can give us a short outline of 2 or 3 key points of the decision and what the decision can mean for the data transfer.
It was important, but I was a little bit surprised that the General Court, it was not the full EU Court of Justice, the General Court actually picked up the case and said something on the merits. I was thinking they would say, Mr. La Tombe doesn't have standing here to challenge the adequacy decision of the EU. So that was a little bit surprising. What it says on the review mechanism within the privacy framework, it's basically what the European Commission has said in its investigation. The issue is not over. First of all, there could be an appeal that takes, 18 months or whatever in Luxembourg. But at the same time, there also the European Commission is called into action to monitor the situation. So if President Trump, in his wisdom, decides to get rid of the executive order 140386, which is the underlying executive order for the privacy framework, that would cause a major issue. But they haven't done it. I remember the night when President Trump took office. On the next day, we were all looking at the list of the Biden executive orders that were rescinded, and we looked at it, 1400 and then 140186, and we said, oh, good. it's great they haven't really taken that away. That would have been a problem. So I think right now it will float along, and companies will use it. I can only say in my practice, I always recommend to have belts and suspenders, as we say here. That means the privacy framework plus something else, like derogations, like standard contractual clauses, whatever, so that you stand on several legs in case something happens. And that is what many companies are doing. So the standard contractual clauses are not going away. But companies here in the US may now say, all right, we continue to register with the data privacy framework. And as long as it's still out there, they will use it.
Yeah, and do you think, or you said how you're handling it, but have you got some insights from other companies, how they're handling it? Yeah, are they afraid at the moment that the executive order could still be, yeah, Trump could, yeah, get rid of it if he wanted to, but at the moment it doesn't look like it.
Yeah, at the moment it doesn't look like it, exactly. Yeah. So we'll have to see. I mean, they have so many other bigger fish to fry right now.
Probably.
It could well be. It could well be that within the discussion here about the EU laws here, Data Service Act and so forth, and the threats from the White House that he may threaten to rescind it. But it's not in his interest. I mean, they make a lot of money here with the data centers and so forth. I like to ride the bike. So if I ride into Virginia here, where there was like lush forest and leafy bike paths, now it's humming. It's data centers. Yeah, there's no one there. Data center, data center, data center. So they build like crazy, I would say. But they build a lot of data centers here, and they want to have the business. So I don't think they want to get rid of the business.
But if we talk about the data transfer, we have to talk about the Cloud Act. So yeah, the Cloud Act grants US authorities to access data held by US companies abroad. And yeah, how do you think this works in practice, or is there, what risks are there at the moment? What do you think?
Yeah, I think the Cloud Act is a little bit overrated in Europe, and they think that it applies on a daily basis. That's not the case. It actually lists out from large companies how many requests they have gotten under the Cloud Act, and it's really not that much. You should remember why it was actually implemented. It was simply implemented to fill a hole in the system. If you are with your organization in the US, if you have an office here, if you have someone here as a representative and so forth, you're already subject to the jurisdiction of the US authorities. And the standard there is custody, possession, or control of data. So only in that case where the cloud provider has custody, protection, or possession of data in Europe, and they don't get it anyways through other means, then they could try to get it through the Cloud Act. And it's for certain specific measures. It's for certain criminal cases only, and it can be challenged in court by a so-called motion to quash. And I think the US companies, the cloud providers, have an interest to challenge the motions because they don't like it either that the US authorities under FIDA or so forth look into their databases and so forth. So and in a way, the means that are there to look into the data, they are not that different from what other states have, and even in Europe, they also want to know for certain criminal cases what's going on, even if the data is overseas and so forth. So I think the Cloud Act is a little bit overrated. I don't say it's not it's a problem at all, not a problem at all. But I would say let's really check into that and fully understand what it covers, what it means, and whether there are cases where it applies or not.
Yeah. Yeah, right. The Cloud Act comes into discussion over and over again. But do you have any cases or precedent falls, that show how far this access really goes, or is it just a theoretically problem?
Well, let's look at the case why they actually implemented the Cloud Act. There was someone in Ireland who was involved in criminal activities with his emails and so forth, and it was serious stuff like drug dealings and so forth. And the US authorities wanted the data, and they wanted it from Ireland. And Ireland says, yeah, we have this MLAT, this agreement here for mutual cooperation, but you have to tell us exactly what you want, and we need to go through the courts and blah, 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 blah. So the US authorities said, sorry, it's really urgent. We would like to look into that really quickly, and they couldn't do it through the mutual agreements. So they decided to get the Cloud Act that they could go to the provider and force the provider in a specific case to give them what they needed here for their investigation. And that is why the Cloud Act came into being. The other cases, I mean, they have published lists how many requests they get, but they don't tell the public, the big cloud providers, what it actually was. But I would say it falls into the same areas.
We do have one question from the audience, so I would read that to you. It's also regarding the Cloud Act. It says, I'm not sure the Cloud Act is so overrated. After all, among other things, it establishes a mutual recognition framework, whereas, for instance, paragraph 110, paragraph 3 of the German Code of Criminal Procedures just contains a blanket authorization for law enforcement to remotely access any data they can get hold of, regardless of where that data may be located.
Yeah, but the Cloud Act doesn't cover any data. The Cloud Act covers, you have to specify what you need and why you need it. And as I've said, you can challenge it in court. And just to mention that, there is in the Rules of Federal Civil Procedures, there is a provision here that allows foreign courts to get a discovery in the United States. The other way around, they do that, and that has been tested here in a Hamburg case, for instance. So it's not that they're not open to international cooperation. It's just that the AMLAT system is outdated, and I've gone through it. You know, discovery, if they want the discovery here, they want millions of documents in some cases. But you don't get that through the AMLAT because you need to specify what exactly you need and so forth. So there's a clash of philosophies here. Here they want to check into the truth and they want to look into everything that's out there. Whereas in Europe, you say, well, if you go to court, you bring your evidence and the court can help you with certain documents and so forth. It's a totally different approach. And to reconcile that, that is difficult. It's very difficult.
Yeah, thank you very much. We're almost out of time, so thank you for your time. I think that was a great overview to what's actually the topic at the moment in the US and the data transfer. The topics always come up again, and I think the overview was very nice for our participants at the end of our conference, at the end of day 1 and day 2 now. Thank you very much for your time.
Thank you very much. If someone has questions, I'm also available via LinkedIn, of course. I'm happy to get in touch. And it's so nice to continue the dialogue and to see what the next steps are. There's always news here in Washington, almost every day. So let's talk about it and let's stay in touch.
Perfect. We're always happy about news from Washington. Thank you and have a good day.
Thank you.
Thank you. Bye.